Hi, Karen. Thanks for joining us today.
Thanks for having me.
Perfect. Let's get right into it. I guess in the past year or so, there's been a lot of discussion about the SEC mandating some ESG disclosure or building some sort of infrastructure around ESG. That brings up the question: is the SEC the proper body to do this? Can they do it? And if they can, should they do it?
It's a great question, and one that I think a number of people in this space have been asking for a while. I think the question, really, gets to the heart of what it is we are concerned about. What is the goal of ESG, and thinking through the role that maybe the SEC and maybe other institutions will play in that space. So I think to get a better picture of this, it's worth thinking through what the SEC is, what it has historically been, and what kind of information it is that they mandate and require of companies. So I guess to go all the way back, the SEC was established in 1934 through the Securities Exchange Act, and it was challenged or sort of mandated by Congress with a three-part mission. And those three prongs of its mission are to ensure capital formation, to allow for fair and efficient markets, and to afford investor protection. And in a number of ways, investor protection seems to be one of the larger of the goals, or sort of maybe it seems that the SEC very much prioritizes that over the other two in many ways. But needless to say, those three goals really are the framework for the SEC's mission. What's interesting is that ESG links to all of those goals in some ways, and that's, I think, what I'd like to talk about for a minute here today. ESG, environmental social governance, those questions really, those issues get to the heart of the values of certain companies. But the issue with the SEC being involved in this and having a role in that is that the SEC is both maybe too narrow of a way to look at this in terms of what their arena and jurisdiction is, and in some ways too broad. And I'll explain that by saying this, which is that what the SEC requires companies to disclose and what they can, what they mandate for companies to do is to require companies to say what is material to investors. And that question of materiality is at the heart of all of ESG, especially as it turns on the SEC's role. The way that securities laws is set up is that investors are protected by means of corporate disclosures. So the way, the premise of all of our securities regime is that investors will be protected if they have a certain amount of information in order to make a sound investment decision. That's really the definition of materiality. It is the total mix of information upon which any investor will rely in making an investment decision. So when you think about the questions and the topics and the information you would learn through ESG disclosures, a lot of that probably is material to investors. The rub has been historically that material information, for the most part, needed to be rooted in financial disclosures, essentially. Meaning, is this investment that I'm putting my money in going to go well or go poorly? And I think the issue with ESG and what some of the critics would say is that some of the topics that are required in terms of disclosure related to ESG might not have a lot to do with whether or not that's a sound investment or not. And I guess what I'll say by that is that historically, like I said, that has been disclosure to help investors decide if this is something that's going to make money or not. And we saw a little bit of an expansion on that concept of materiality, but ESG is a broad sweep, but a much in terms of what in addition will be required to be disclosed. Maybe one way to explain this better is to think through something that I spent a lot of time researching and writing about, and that is conflict minerals. And conflict minerals came out in Dodd-Frank in terms of being a required disclosure for companies. And just by way of background, conflict minerals are defined in Dodd-Frank as 4 minerals that are found in the Democratic Republic of Congo or one of their neighbors. So these 4 minerals, if if a company has any products that contain those minerals, they needed to disclose that in order to be in compliance with 1502 of Dodd-Frank. And at that time, my argument was, and a number of people's argument was, that that is an improper use of the securities law and of the SEC, because investors at the time didn't really care. Meaning, if we know that Boeing uses some conflict minerals and they disclose that, is that going to move their stock price? Are investors going to get out of that stock? I argued this is not the way to set up a disclosure regime, because it's tied to what is immaterial information. Investors didn't care. What is different about ESG, and I think the reason ESG is going to be long lasting and it's here to stay, is that unlike the conflict minerals rule, which was just, a pet project of a number of people in Congress that required that disclosure, unlike that, ESG is coming from the ground up, meaning investors are asking for it. We've seen the institutional investors come out making statements about needing this, with the BlackRock, Vanguards of the world saying, we care about this. We want this to be something companies tell us, and we will base investment decisions around what it is companies disclose in terms of their ESG commitment. And so that's different than a required disclosure without much sort of grounding in whether or not investors care. Here we have the opposite situation, which is investors are saying they care. Granted that a lot of these are institutional investors, and I think we can talk in a minute about the difference maybe in institutional investors versus retail investors. But I think the fact that this is, again, a groundswell from investing communities saying these are issues we care about, particularly with things like climate risk, diversity inclusion, governance structures, that will actually inform whether or not we invest in this company. And one last thing I'll say, getting back to the role of the SEC there, is that, at the end of the day, you could have maybe made the argument that something like a conflict minerals disclosure is not, investors didn't care, I didn't think at the time, so it was fairly immaterial. But more than that, it didn't maybe create any broader risk. So there's no risk to either financial firms or to the market more broadly if people say or don't say if they use these minerals. I think with ESG, we're at a place now, even though, we're 15 years almost after the conflict minerals rule. And I think that's actually an important fact. We're in a different place now. And there is actual systemic risk with things that are related to ESG. It would be hard to make an argument to say these topics don't hit the bottom line. I mean, you can't argue that if you're in the extractive industries or any other, a number of industries where you're not factoring in potential climate risk, that will hit the bottom line of your company. And so, like I said, this ends up, I think, being rightly housed with the SEC because of 2 reasons. Investors care. They want to know about this. They could have said this is material information and they want disclosures on it. And then secondly, I think this actually does tie to the role of ensuring that the markets are not volatile and that they're stable, because a lot of these topics and discussions around ESG are involved with systemic risk issues. So that was a long windup on that question, but I hope that gets to some of what you're getting at with this idea of whether the SEC is the appropriate body to handle this. I think they are, and I think there should be other maybe agencies involved as well. When I mentioned systemic risk, off the top of my head, you think of the Financial Stability Oversight Council, which came out of Dodd-Frank for exactly this discussion of looking at systemic risk across industries and across markets. So there might be other players in this space who want to weigh in if this truly is something that will affect markets. And there also might be other agencies tailored to the topic, meaning if we're talking about climate, there might be other players in the room that know about the climate issues in a way that the SEC might not. So that I think that's why I meant it was both maybe overly narrow and overly broad to have the SEC be the only regulator in this space.
That's really some really great insight. Uh, for example, you mentioned materiality, and that's a big issue even within certain industries. You look at the SASB disclosure framework, and they break it down by industry. So I'd be curious if, for example, if we assume that the SEC were to move forward tomorrow, how would they how would they determine what's material for different industries? Because I assume that different companies have different things that are material for their investors.
Right. That's the blessing and the curse of all of the materiality determinations. And it's why I think everyone is still really hand-wringing around this idea, because how do we narrow and get our arms around what is considered material? I think you're right. The SASB framework and considering this by industry is something that will play a huge role. Like I said, there hasn't been any bright line rule around materiality. The courts have very much shied away from creating a quantitative measurement, meaning if this hits 5% of your revenue or assets or whatever it is, that is de facto material, or that less than that is de facto immaterial. They very much shied away from that and have handled this on a more case-by-case factual basis. And so there's not a lot of guidance necessarily from previous cases when materiality has been challenged. And so it's something that I think creates, honestly, a lot of jobs for lawyers and compliance professionals and securities, people in the securities space, because it is a moving target, which is, makes people, I think, sometimes stay awake at night out of concern that they're getting close to the line. But like I say, I think it is, I think there'll be additional cases on this. I think there'll be hopefully additional guidance from the agency on it. And so we'll hopefully get a better understanding of what the maybe dotted line parameters are around materiality. And so I know that wasn't maybe an unsatisfactory answer, but I think the problem is that it is not that clear at this point.
Perfect. And I have another question along that line. You were right. I am interested in the differences between institutional and retail investors. So how do we balance the difference between those interests?
That's a good point. And I guess I would say it's hard to draw with sort of broad strokes on the differing interests of those two important entities, I guess I would say. And just like ESG is a broad umbrella, I actually think that, not to get off the topic of this particular question, but ESG, I should say, is tricky because it's so broad. I mean, you're talking about environmental, social, and governance. And just by way of example, you could have a company that maybe meets all of the environmental sort of qualifications, but has, very little insight into the boardroom or has a captured board by the CEO. There's not much governance that allows for more stakeholders to have their voice heard. Does that company meet ESG? Or let's say they have some issues in their labor force in the supply chain, but they're really environmentally sound. There's a lot there that ESG creates other questions there too. And I think there's an analogy a little bit to retail investors. And I say that only because when the retail investor, institutional investor divide, if you can call it that, is that there are interests in those groups that align with maybe certain elements of ESG and not with others, or there could be, a group of, funds that are only geared toward sustainability, but then might sort of drop the ball in terms of how the company is governed and the structure of the company. And so I think between retail investors, I would see that those individuals might have more sort of verve, zest, whatever it is, passion for certain elements of the ESG framework. Whereas the institutional investors are focused much more on, I think, the bottom line still, and thinking about this as an important move to ensure that those investments are sound. Meaning they're hewing, I think, a little more toward the historical, traditional understanding of materiality, but recognizing that the ESG factors actually do speak to that traditional understanding of materiality, meaning these things hit the bottom line. So I think you see sometimes more push from retail investors to move the needle more in the space of what is sort of traditionally the CSR type idea, like corporate social responsibility, ensuring that these are good companies. Whereas institutional investors, for as much as they talk about how important that is, I think they still are, this is the business, and they need to make sure that that doesn't mean that there will be huge hits in terms of their, big stakes in some of these companies. That's my sort of high level take. I think if we drilled down more, we'd see obviously a lot more nuance and color in both of those groups. But I think I say that only because the auditing framework, the things that the institutional investors will really need to be doing to ensure that their investments are meeting these frameworks will be more kind of in the weeds and technical and tied to the finances, maybe then some of the sort of more passion ideas, interests, special interests that retail investors might be focused on.
Yeah, absolutely. And lastly, we always like to look into the future, play a little crystal ball. So where do you see ESG moving in the next years to come? It certainly sounds like a positive one for lawyers, the work required.
It's fair. Well, like I said, I think with what we saw with conflict minerals and some of the sister provisions we saw in Dodd-Frank that required additional disclosures as the solution to things that I argued were more sort of foreign policy in nature, the extractive industries disclosures, the conflict minerals disclosures. There have been a few others that just seemed misplaced a little bit in the disclosure regime. I think in this case for ESG, because of where it has originated from and where really the drumbeat, the steady drumbeat for ESG disclosures is coming from, it really does feel more of a bottom-up type approach as opposed to mandated by statute or by Congress. And I think that alone means that it's here to stay. Like I said, because of just the definition of materiality, it's things investors care about. And this is something they care about. So I do not see it going away anytime soon. I think that it will have to get clarified, narrowed in certain places because it is so disparate in terms of all the issues that come into that big tent of ESG. As I mentioned a minute ago, I think there will be places where we'll see discrete maybe or tailored requirements on the different topics within ESG. So, like climate risk disclosures, and then the things maybe, we've seen some with governance and say on pay, things that, it might still feel very piecemeal, but all under the broader umbrella of ESG. So I really do think that, one, I assume most companies now have certainly been aware of ESG for a few years and have it on their radar. But I think it's one that will only get bigger in terms of the field of view that ESG will take over, especially as we see, again, more technical requirements, hopefully that brings some clarity in terms of the auditing, checking that, we're not greenwashing, that kind of thing. So I think this will be a priority and the thing to be watching for a number of years to come.
Well, perfect. Thank you again, Karen. I really appreciate some of the insight you provided today. It was fantastic speaking with you.
Thank you, Anakat. This is great. I appreciate it.